and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
On March 10th, 2025, officers initiated a traffic stop at 4841 block of Mount Houston Road in Harris County, Texas. Numerous vehicles were observed inside of a parking lot in a pit. The officer observed the defendant driving a white Honda, engaging in reckless driving by doing approximately 4 donuts. The defendant's vehicle was coming close to hitting people standing by the pit and other vehicles as well, disregarding the safety of the other people and their property. The defendant was the only occupant of the vehicle.
She's the only occupant?
Yes.
Okay, can you run his license, please?
Right. Yes, Your Honor.
Mr. Perez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive in a reckless manner again, not to do donuts, street takeovers, racing, any of this nature. If you do, first I'm going to put you in jail. Next, I will take your ability to drive away from you. Do you understand?
Yes, sir.
It's valid, Your Honor.
All right, you're not allowed to drive unless you also have valid liability insurance in your name.
Sir.
That is a condition of your bond as well. So if you don't have car insurance, you're not allowed to drive. Do you have a lawyer today?
No, sir.
Do you have the ability to hire a lawyer? I'll have you fill out an application. I'll see whether you qualify. Do not leave until you sign our bond conditions. Deputy Miranda's going to give you an application. I'll have you sign a reset with Victoria, and then we'll have you take your seat in the jury box.
Can you say something?
No. Ma'am, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am. Okay.
On March 10th, 2025, at approximately 1 a.m., officers conducted a traffic stop at the 16,000 block of Katy Freeway on a white Lexus for speeding. The officer paced the motor vehicle traveling 85 miles per hour in a 60 miles per hour zone for approximately a quarter mile. The motor vehicle was also failing to maintain a single lane. The officer made contact with the defendant, the driver. The officer observed a strong odor of an alcoholic beverage, slurred speech, red glassy eyes, and the inability to balance. The defendant admitted to having 2 drinks prior to driving the motor vehicle. SFSTs were conducted. There was a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The DIC was read and she consented to breath. The results were a .187 and a .185. She was identified by her driver's license.
So any prior to WIs and then
No prior to WIs, her license is eligible.
that. All right, Ms. Olvera, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond, put you in jail. No more PR bonds. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him, and he'll tell you if and when you have to come back to court. If I find that you pick up a new case, you're driving without insurance, anything.
Olivera. Amendment.
Ms. Olvera, come up.
Yes, I'm not in the market.
You are Catherine Olvera. Ma'am, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am. Okay.
On March 10th, 2025, at approximately 1 a.m., officers conducted a traffic stop at the 16,000 block of Katy Freeway on a white Lexus for speeding. The officer paced the motor vehicle traveling 85 miles per hour in a 60 miles per hour zone for approximately a quarter mile. The motor vehicle was also failing to maintain a single lane. The officer made contact with the defendant, the driver. The officer observed a strong odor of an alcoholic beverage, slurred speech, red glassy eyes, and the inability to balance. The defendant admitted to having 2 drinks prior to driving the motor vehicle. SFSTs were conducted. There was a 6 out of 6 on the HGN, a 5 out of 8 on the walk and turn, and a 1 out of 4 on the one-leg stand. The DIC was read and she consented to breath. The results were a .187 and a .185. She was identified by her driver's license.
So any prior to WIs and then
No prior to WIs, her license is eligible.
that. All right, Ms. Olvera, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I will revoke your bond, put you in jail. No more PR bonds. You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with him, and he'll tell you if and when you have to come back to court. If I find that you pick up a new case, you're driving without insurance, anything else, then it's not going to go well for you. I'll have you sign a reset with Victoria. We'll have you get with Fleischer if your bond conditions, and then you're free.
Right off the bat, you can feel the tension. This isn't just routine court. There's already a sense that something's about to go sideways. Stay close, because the details here matter more than they seem.
Hey, Judge.
Thanks, Mr. Nolan.
That's great.
If you said Kamisha Johnson,
Yes, is that how you pronounce your name?
no.
Yes, sir.
Yes, Judge. Kamisha Johnson.
Appointed on the case?
Yes,
Did you just get appointed to the case?
got a point today, Judge.
Okay.
Judge, we already found PC and did bond condition.
Yeah, I thought we did.
Just waiting on council for a reset date.
Okay. Yeah, you're good to go. Just, ma'am, don't drive. Above all else in the short life that we have, don't. I don't care what your justification is. If you drive, it's really not going to go well for you. Do you understand? All you got to do is get your Texas driver license, liability insurance, show us that you got it, and then I'm happily take all these conditions off.
Can I ask a question? If I do my occupational license, then could
You
you?
need to call DPS first, because if you've never had a license, that's going to be an issue. So you need to call them first to see what you need to do. Don't just try to apply and start spending 150 to,
I went there, that's why I have asked you.
don't just start, I can't give you legal advice. The only thing I would say is go to DPS, call them, and they can tell you what you need to do to actually get your license. Why are you going to pay all this money to get an occupation when you should go get your regular license?
Because on the chart, it says that I have to have an occupational for like a amount of time in order to release the license.
I don't know if I would grant you one. I really don't. I'd have to look at a lot of things. First things first, though, is call DPS. This is the number of the driver's license division. Call them at 7 in the morning. Otherwise, you'll never get through. Don't call at 8:01, 9:32. You'll never get through because the phone lines, you have to call it right when they open, which is at 7. Call them and figure out what you need to do to try to get it back. And that's what you need to do first and foremost. Okay?
Great. Thank you, Judge.
All right.
Johnson.
If you said Kamisha Johnson,
Yes, is that how you pronounce your name?
Yes, sir.
Yes, Judge. Kamisha Johnson.
appointed on the case?
Yes,
Did you just get appointed to the case?
got a point today, Judge.
Okay.
Judge, we already found PC and did bond condition.
Yeah, I thought we did.
Just waiting on council for a reset date.
Okay. Yeah, you're good to go. Just, ma'am, don't drive. Above all else in the short life that we have, don't. I don't care what your justification is. If you drive, it's really not going to go well for you. Do you understand? All you got to do is get your Texas driver license, liability insurance, show us that you got it, and then I'm happily take all these conditions off.
Can I ask a question? If I do my occupational license, then could
You
you?
need to call DPS first, because if you've never had a license, that's going to be an issue. So you need to call them first to see what you need to do. Don't just try to apply and start spending 150 to,
I went there, that's why I have asked you.
don't just start, I can't give you legal advice. The only thing I would say is go to DPS, call them, and they can tell you what you need to do to actually get your license. Why are you going to pay all this money to get an occupation when you should go get your regular license?
Because on the chart, it says that I have to have an occupational for like a amount of time in order to release the license.
I don't know if I would grant you one. I really don't. I'd have to look at a lot of things. First things first, though, is call DPS. This is the number of the driver's license division. Call them at 7 in the morning. Otherwise, you'll never get through. Don't call at 8:01, 9:32. You'll never get through because the phone lines, you have to call it right when they open, which is at 7. Call them and figure out what you need to do to try to get it back. And that's what you need to do first and foremost. Okay? Great. Thank you.
So, my name is Judge Fleischer. How are you doing? I have Jonathan Lopez on docket today. It's a violation of bond conditions. After speaking with him and looking at it, it looks like he signed for bond conditions on March 5th, and that was filed on March 5th, and that stated an address. However, another bond condition, an amended bond conditions, was filed on March 10th with that address crossed out and a new one added in. He wasn't aware of that, and that's the address that he went to for this violation of bond conditions. He's here.
Yeah, if I needed to, this was the case
Yeah.
where we came back for a main Moab. Brad was the attorney on it. He came in, he scratched out the old address. It looks like, based on what I saw, his client had initialed it, Brad had initialed it, and we sustained it. And it looks like as soon as he got out of jail, he went to that address.
He's not aware of those. Let me pull it up.
So you're saying he did?
Yes, Judge. On the amended book, there's his initials on the amended book, as well as the attorney.
I'll advise him. He was stating that he was unaware that that's why he was initialing. I told him I'll address it with him, but it's a presumption that he knows what he's signing. But I did tell him that I will bring it to your attention.
Does he want?
He's just basically saying that he didn't know what address that he was supposed to be prohibited from. He was under the impression that he's still supposed to be prohibited from the 20915 Bar Street and not Owens. I told him I would address it with you.
Okay.
We could bring him out if you want to.
I don't know. It's up to you. I mean, if you want to, but it looks like he's got a high bond on the felony case, huh?
Yeah.
And he's not made bond on that case, so he's got a high bond on our case as well.
Your Honor, I think it's actually, so there's two Jonathan Lopez on the docket. One's a VPO.
Oh,
Sorry, Your Honor. I know what case you're talking about too.
I see.
Oh, this one is just a misdemeanor. This
I have literally two Jonathan
and
Lopez's.
Lopez's. Yes.
You're wrong.
I have Santos.
Your Honor.
That's why.
So this one, no, he just has this VPO. I did talk to the state. I understand the concerns. I just wanted to bring this to your attention because he's saying that he was unaware of the change of address.
I told him over and over and over. Can you bring him out? Jonathan Lopez? Santos. Here. Hold on, let me make sure.
This is a critical legal moment. When you're on felony probation, any violation, especially drugs or alcohol, can land you straight in jail. The judge isn't just reacting emotionally here. This is about enforcing court orders.
Here, you get the right one. Bottom of 38, yeah. If he tries to tell me that he didn't know, I mean, how many times did we say?
Well, this is the case where the plea was re-entered after the motion was amended, so then you advised him and admonished him once more.
Yeah. I told him I would bring it to your attention, Judge, so.
So this is the one where we did, we did the plea on the terroristic threat, right? The terroristic threat, the evading were dismissed. Oh, two terroristic threats and evading were dismissed, right?
That wasn't with me, Judge.
Yes, Judge.
Okay, so no, it was just one terroristic threat.
One terroristic
Yeah,
threat.
it was just one. How's jail? Some just don't get it. I mean, I'm truly at a loss. Truly at a loss. When we did the plea, not 6-7 days ago, I told you probably 25 times, don't go back. And now here, you've picked up a violation of a bond condition of protective order. Let's do probable cause because I don't know. You have the right to remain silent. Anything you say can and will be used against you, sir. Please.
On March 12, 2025 in Harris County, Texas, officers were dispatched to a violation of protective order call. The officer met with the complainant who stated that she found the defendant in her mother's house while there was an active protective order, including a residency restriction. The officer arrived and found the defendant at the location and confirmed there was a protective order prohibiting the defendant from being at the location.
So it goes back to mom's house.
Yes, Judge.
Not the.
Yes, Judge. He went back to the residence.
I don't know what we're gonna, I don't know,
I just want to make sure that he knows, or that I wasn't there on the plea before. I just seen like the two different filings. He's saying that he didn't know the address.
problem is that we have the wrong address.
Right.
So we amended.
So he was admonished about the new address.
And so far as the lawyer even went to the jail to go talk to him.
Okay.
To tell him. So I did,
Okay.
the lawyer did.
Okay. Well, thank you, Judge. I didn't know that.
I don't know if you're gonna get out, but let me tell you something, and I want to make this really clear to you, Mr. Lopez, is that now, with what you were charged with, the Texas Constitution does not allow me, but in extremely limited circumstances, this being one of those, to have a hearing to hold you at no bond. Zero bond. This is that type of offense. I don't know if you're gonna get out. I don't know if anyone is gonna pony up the $5,000 to get you out. If someone does, I'm going to put an ankle monitor on you. If I find that you violate any of the conditions that I'm going to put on you now, I will have a hearing to hold you at no bond. Do you understand? I don't know what it's going to take to get you to hear me, but perhaps that may be it. I don't want you to have any contact with the complaining witness in this case. I don't want you to have any contact with mom. I don't want you to have any contact with dad. I don't want you to have any weapons. I don't want you to go within 1,000 feet of where they live, where they work, and the address listed in this order for protection. Do you understand?
Can I have the address, sir? The correct address.
We will give it to you. Prior to me, I'm going to tell you this now, Ms. Strong, that prior to me accepting anything, any kind of plea bargain in this case, I would like to have a TRAS done to see how we go forward. Because I'm going to tell you now that every time that something it's, and
I understand, Judge.
okay, all right,
Absolutely.
okay. So we need him to sign conditions real quick, and then we'll give him a copy of the MOA right here, and then he can go back.
Thank you.
Sure. And I'm going to find probable cause as well.
Okay.
That panic you're hearing? That's real. But notice the judge shutting it down, because anything said right now can actually hurt her case later. Silence, in court, is often protection.
Do you know what your lawyer had worked out for you to do, sir?
Today?
No. What you were supposed to do between the last setting and today, what were you supposed to do?
They told me I needed to go to a mental health evaluation or something like that.
All you had to do was walk in, tell them that you're there to do it, and then they would have done the assessment.
Okay.
I don't understand why it never got done.
I would suggest not a reason, because he's gonna give you a week. That's my suggestion.
Yeah, that's all I need. Okay, so,
Your case is 250 days old.
yes, sir.
Unacceptable that it's gotten this old.
I know, sir.
I will give you a week. If
Thank
you
you.
don't have it done in a week, I'm going to set your case for trial. And I'm not giving you any more resets.
Okay,
You'll be put to trial.
that's good enough, sir.
1 week.
Yes, sir.
If you
Yes,
don't
sir.
understand what to do, Mr. Nguyen can help you out.
That's why I
Just no more excuses.
Okay, yes, sir.
Thank you, sir.
Thank you so much.
I'll get you. So,
I'm here today on Carl Lee Powell. He's in custody. It's a bail review setting. He has a felony attached, and I did I spoke to DVD about the situation, and it is a little confusing because it appears.
Bond on a case, please.
What's your cause number?
It's going to be Jaden Bolding. His cause number is 255-4634. 255-4634.
Okay, give me a second. Let me make sure everybody
Yes, sir.
gets it. You got it? Yes. No. 255-4634.
255-4634. Yes, sir.
34. No, 4634.
Okay.
Okay, you want to bring your client?
Yes, sir.
I'm sorry, what was that case number?
255-4634. It's an off-docket arraignment.
We need a PSR on that one.
Yeah. Good morning, sir. Give me one second. Did you hear that?
Yes, I got it, but I haven't done the PSR.
Take it down. All right, good morning, Mr. Bowling.
Good morning, Your Honor.
Mr. Bowling, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 7th, 2025, in Harris County, Texas, officers were dispatched to a mental health call and met with the witness and the complainant, who are the stepfather and mother of the defendant. The witness stated that the defendant suffered from an undiagnosed mental illness, which caused him to get triggered. The defendant was triggered by clothes lying on the bed and started to argue. The defendant grabbed a pair of scissors, which the complainant took from him before the defendant struck the complainant several times, causing pain. I'm sorry?
Struck who?
The complainant.
I know.
Who is stepfather, Your Honor?
The stepfather.
All right, Mr. Bowling, I'm going to find that there's sufficient probable cause to go forward with your case. I am now entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Mr. Lawson as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate threat or harassing behavior. You cannot be in possession of a weapon. This usually comes with a residential restriction. We need to figure out, are they here?
They're not, but the state has
We
conferred.
have spoke with them, and the complainant does want the defendant back at the residence.
I will take off the residential restriction. How old are you, sir?
I'm 27.
You are not to consume alcohol, illegal drugs, or unprescribed controlled medication. And I'm telling you now that I'm going to test you for marijuana. If I find that you're using, it's not going to go well for you. Do you understand me?
Yes, sir.
I promise you, you're going to get tested. If I find that you're using, I will revoke your bond, put you in jail, no more PR bonds. I'm going to give you a PR bond today so that you don't go to jail. But if I find that you become a danger to my community, I will do everything in my power to protect every single person. I don't care what your excuse is. I don't care what you're going through. If there are issues, now is the time for you to take care of them. I hope that this is enough of a wake-up call that I don't have to put you in custody, because we have enough people in there now as it is. What do you do with yourself?
You, sir?
Are you in school? What do you do?
I'm planning on going back to college, sir. But I cut hair and I produce and I engineer music, sir.
Okay.
Don't you work at
You graduate from high
Oh,
school?
and I work at HEB. Sorry, HEB is like my job, but it's in career.
What about high school? Did you finish high school?
Yes, sir. I graduated.
It's time for you now to also start thinking of the future. You know, the more education you get, the more money you're going to make in life. And I'm going to tell you, this life is so great if you have money, and it's so terribly awful when you don't. I promise you. The farther you go, the more knowledge you get, because knowledge is power. This is what you're going to get. This is not good. Now you have a lawyer. Have you signed on yet?
I will today, Judge.
I need you to sign on. I have attorney of records in the tower. You have a lawyer. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court. But you've got to stay in touch with him, and he'll tell you if and when you have to come back. You're going to get tested. Don't use. You understand?
So,
Okay. Guys, bond, any recommendation?
We would ask for maybe a $500 surety bond, not anything.
Do you have any priors?
He has no priors.
No priors, Your Honor. And due to the mental health concern of the case, we wouldn't.
Surety bond's going to do what?
I spoke to the DVD prosecutor as well, and that's what he conveyed.
Well, I'm going to give you a PR bond. I'll set your bond at $100.
thank you, Your Honor.
Now we're seeing the human side of the system, family responsibilities, stress, real-life pressure. But here's the hard truth. Courts expect compliance no matter what's going on outside.
Just make me proud. That's all I'm asking you to do, man.
Sir.
So what we're going to do now is I'm going to have you go sign a reset with Victoria. We'll have you take a seat while we generate all the paperwork. You will meet with Felicia for your bond conditions, and after that, you're free to go.
Very good.
Thank you, Judge.
So can you file no threatening, harassing, and no weapons, please?
What's the case?
Mr. Munoz Puente, you are charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine.
$2 de multa.
You're going to do probable cause. You have the right to remain silent. anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, sir. On July 4th, 2019, the officer observed a white Ford Mustang pull out of a Citgo gas station parking lot onto the 200 block of East Little York Road. The officer observed the Mustang fail to drive in its designated lane, driving over the striped white line in between lanes 1 and 2 multiple times, while other vehicles were on the roadway. The defendant was unable to control its speed and accelerated and decelerated multiple times. A traffic stop was initiated. The defendant was observed to have red glossy eyes, slurred speech, and swaying while he was standing. The officer also observed a strong odor of an alcoholic beverage. The defendant admitted to drinking 5 beers, and standard filter sobriety tests were administered. HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. 2 spilled beers were found in the vehicle, and a search warrant was drawn and executed for the blood.
Why is this case 2,083 days old?
Just so, speaking to him, in 2019, he was arrested in the ICE detainer that was hit. He was picked up by immigration. He said when he was in the immigration court, they told him he could sign a waiver.
Voluntary departure.
Yeah, voluntary departure, that's what he did.
Mr. Munoz pointed, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medications. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond and I'm going to put you in jail. I don't know what your immigration status is now. You now know what happens when you go to jail. They will possibly deport you. And I'm going to tell you, if you come back and you don't come back with the proper documentation, it could be 5 years minimum in federal custody on an illegal reentry charge. So when you do things the right way, good things happen. When you don't, there are serious consequences. If I find that you violate any of these conditions, I will put you in jail. Do you understand? You want his license, see if he has a valid license plate.
There's no license on file, Your Honor.
You are not allowed to drive. That is my most important position in this area now. If I find that you drive, I don't care what you I can have a contempt hearing. You can be facing an additional 6 months jail and $500 fine. I will have you sign with me now an affidavit. This is a promise that you're going to make to me that you're not going to drive. I don't care what is going on in your life. If you don't have a license, a Texas license, and liability insurance in your name, you are not allowed to drive. You run his NCIC, as a priority to the eyes, please.
Yes, Judge, I'll run it.
Your case number? It's 226-7399.
Your Honor, it appears based on the NCIC, there's a pending DWI out of Dallas County as well.
That's correct, Judge. He does have another open DWI in Dallas County. We picked it up before this case, but it was a warrant for both of them, which was picked up for when he paid bond for both of these cases. So before he was deported, he had picked up both those DWIs.
Did you get a PR bond in this case? Munoz pointed that.
GOB jurisdiction, but it was First Road, that's here, and then he posted a
I'm going to put an ankle monitor on you, and I'm now giving you a code 7 to 7. If I find that you're out past 7 p.m., I
Sale después de las 7 de la noche.
I will do everything in my power to protect the community at all costs. Do you understand?
No entiendo. Yes.
Unacceptable. Counsel, were you going to say something?
This is where things get messy. Promised dismissals that never happened? That's not just frustrating. It can seriously impact someone's entire defense strategy. Question is, was it bad luck or breakdown in the system?
If I find
Yo averiguo.
that you test positive for anything, and I don't care what it is, if you try to come here and try to tell me that it's mouthwash, it's a tequila lollipop, it's hair dye, it's mustache ointment, I will literally,
Bigote.
if I find that you are driving a car, holy moly, I will absolutely lose it. Do you understand?
¿Lo entiendes?
Don't dare
Te atrevas
get near a car.
a acercarte a un automóvil.
So 7 to 7 curfew,
Desde 7 horas en su trabajo.
scram monitor, no alcohol, no drugs. Is all discovery in?
Yes, Judge, everything did.
Okay. So counsel, I'm going to give you a 30-day setting. At that point, you got to come back and let us know what you want to do. And then you have 30 days to go through all the discovery with your lawyer. And you come back at that time, I'm going to either set your case for trial or you will accept the plea bargain for the agreement. But at 2,000, and I know that the issues may have happened, but with another DWI open, it's time to do something about it. Okay, all right.
Thank you, Judge.
See you soon. So, when was the first time we tested him?
I believe February the 13th. I'm sorry, not the 13th. It was 2 weeks ago.
2 weeks ago. I have a note from the 10th saying that he tested positive for THC. We were just awaiting to see confirmation from the lab.
The lab confirmation has not come back.
When did we first test him, please?
Judge, 1 second, please. For Diego?
When was the first, we ordered him not to use when he first got here, correct? But this case has been on docket for 64 days and you've continued to use. I have ordered you not to use. You just tested positive. You first came here 64 days ago. I ordered you not to use and you tested positive yesterday?
Sorry, Judge, it's loading.
Take your time.
I have positive on January 17th and then a positive on 3/10.
He was, I understand the test, but my client's very comfortable with me and he was quite confused as to how the results came up positive because
I can tell you why. Hey, I'm revoking your bond. You're going into custody. He goes with you. I told you. And here's what we'll do. We'll give it a couple days. I'll admonish him. Let him out. And we'll clean out. If he cleans, great. If he doesn't,
he goes back in. Can a couple days be like Wednesday?
I'm okay with Thursday.
Okay.
Yeah, for sure.
And for Baptiste, I had filed a motion to withdraw in your queue.
Is he his own land?
Huh? No, he's not on docket. And he doesn't have an attorney, so I don't know if the court wants to appoint.
I don't see him in the docket today.
Oh, he's not. I'm just.
No. So we got to get him on the docket.
It's on the docket. And then
Right. I don't just grant because before I've done it, granted, and the defendant gets here, where's my lawyer? I just gave him money.
Okay, that makes sense.
So
On docket,
they
okay.
would have and or a $4,000 fine. You guys have worked out an agreement where they're offering you 1 year in Harris County Jail to be probated for 15 months. You will do a repeat offender DWI education class, 2 victim impact panels. You must also do a TRAS to see what other conditions you may need. You must fulfill all those conditions. If you don't, then into jail you will go. We will have a hearing. You will be facing a year in jail. You must do a TRAS, no drugs, no alcohol, guardian interlock, and 25 hours of community service. Is this how you understand the agreement, sir? You are giving up to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, there's no turning around. What happens on the next one? What happens?
Jail time.
No.
Well, no. Enhanced, yeah, felony.
Prison time. 2 to 10 in the penitentiary is what you will be facing if you ever pick up another DWI. If I were you, even a sip of alcohol, I wouldn't get into a car.
And here's the bigger picture. Delays, miscommunication, and shifting personnel can completely derail justice. So let me ask you, should someone's case hinge on who happens to still be in the office?
You need to understand that this is big business in Texas. And now there is also a surcharge that you will be required to pay because of this. Is it true or untrue that is a 0.15 or above? True the enhancement. You will be required to pay the $4,500 surcharge plus court costs that will be assessed in this case. And I'm going to tell you now, if you don't, every $100 that you owe, you will sit 1 day in jail. Do you understand?
Your Honor.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, you are stuck with this. You can never change this. You understand?
Yes, sir.
Is this what you want to do?
Yes, Your Honor.
How do you plead to the offer? Or how do you plead to the agreement?
Guilty.
What does he have now? Does he have a guardian interlock?
Yes, he does, Your Honor.
You get the case number?
No, I think.
Okay. I had it up and then I was like, maybe she has it. It's 2522036. Okay.
Okay, Mr. Messina.
Señor Lucina, buenos días.
Mr. Messina, you were
Señor Mess-
charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they are offering you 45 days in jail with credit for the 15 days that you have done.
¿Qué ya sirvió?
You need to understand that there is an affirmative finding of family violence in this case. What that means is that you can never own a gun or ammunition as a result of this case.
Por este caso. Okay.
Also, if you ever pick up another one of these cases again, you will be facing a 3rd-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. You understand?
¿Lo entiende? I understand.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law.
Leyes federales. I'm a citizen.
You give up the right to appeal.
A una apelación.
Once you accept this agreement, you're stuck with this. It will go on your record. It will be there for the rest of your life.
Y por todo su vida. Understood.
Knowing this, do you still want to go through with this plea?
Sabiendo todo, ¿quieres seguir con esta declaración? Yes.
How do you plead to the offense of assault of a family member? Guilty or not guilty?
Guilty.
I will find you
Voy a
guilty.
hallarlo culpable.
I will sentence you to the agreement. Does this take care of the case upstairs? As a result of you pleading guilty to this offense, the injury to the elderly that you have, the felony case is going to get dismissed. I will tell you now, there's not many times that agreements like this will be offered. So if you are a person that has lack of self-control issues, find another way to deal with the aggression. People, children, but that's not the right way. All right. Good luck to you, sir. Thank you, Mrs. Saldana.
Thank you, Judge.
Okay, are you ready, Ms. Strong?
Oh, here.
So let me come up. So let me get this straight. You plead guilty last week to a terrorist threat. I told you as part